Good afternoon and welcome. Thank you all so much for signing on to join us for our lunch hour training. We are going to be focusing on fair housing rights for Native American communities this afternoon. Thank you so much for taking a little bit of time to join us. I'm Liz Keegan. I'm the Director of Education and Outreach at the Fair Housing Center. I'll be joined by Lindsay Owens, our Education and Outreach Coordinator, and Brianna Miranda is behind the scenes. If you need any assistance, feel free to reach out using the chat. Just a little bit of housekeeping before we get started. You are all muted and your cameras are automatically off, so we cannot hear you or see you. Please do use the Q&A feature to submit any questions that you have about the content. If we can have a moment to address it, if it's about something that we're talking about at that moment, we will do our best to address those, but we will also save time for questions at the end. We also will have all of our contact information available on the slides. You should have received some handouts from us, so feel free to email us with any follow-up questions that are more detailed or nuanced, and we'd be happy to either correspond with you or set up a time to talk. You should all receive an evaluation through the internet browser that should be open after we end our webinar today. You can utilize the evaluation to request a certificate, but please do make sure you complete that fully and mark that you would like to receive a certificate by mail if you would like to do so. We are recording the training today, and we have recorded the previous two trainings that we did in this series, and they're all available on our YouTube channel, which is linked there on the slide. So again, we welcome questions and are going to go ahead and dive in and get started. So as I mentioned, I'll have Lindsay Owens presenting with me today. We'll kind of go back and forth, so they will join us in a little bit. But we also invite you to follow us on Facebook and on LinkedIn, and also visit our website if you haven't done so already. We have a lot of good information available on our website. So we prepared a lot of information to talk about today. We'll look at fair housing laws, protections that are in place, and some of the trends that we want to make sure all of you fellow advocates are aware of. We'll talk about the background on fair housing and how it applies and impacts Native American communities. And then we have a handful of focus areas that we'll do slightly deeper dives into, including the race, color, and national origin protections under the fair housing laws, limited English proficiency. We'll talk about harassment and criminal record screening briefly. We'll look at some lending cases and occupancy standards for rental housing, and then talk briefly about our testing program and how you can report housing discrimination. So I do want to share a content warning because this training does contain a number of real life examples of housing discrimination and other incidences that might be traumatizing or difficult to hear and discuss. So please do be sure to take care of yourselves. With that, I will turn it over to Lindsay to talk a little bit about our Fair Housing Center.
Sounds good. Thank you so much, Liz. I will dive in a bit to talk about our organization before we talk about fair housing. So the Fair Housing Center West Michigan, or our acronym FHCWM, was founded in 1980 as a private nonprofit fair housing organization. Our mission is to prevent and eliminate illegal housing discrimination, ensure equal housing opportunity, and promote inclusive communities. We do this by providing comprehensive fair housing services, including education, like what you're receiving today, outreach, enforcement, advocacy, and investigation. So some of this work looks like conducting investigations of housing discrimination, and some other parts of this work are providing education to the housing industry, home seekers, and advocates like yourselves. A few disclaimers are that our organization does not have attorneys on staff, therefore we cannot provide legal advice. And so all information provided today is for educational purposes only. Additionally, another thing we want to note is that all information in this training is current to the best of our knowledge, but it could change at any time. Sometimes with the words fair housing in our name, it can be a bit confusing about what our organization does and what we don't do. So to clarify, here's some things our organization does not do. We don't address landlord or tenant law or matters. We don't handle building code or maintenance issues or teach homebuyers classes or teach credit counseling. We don't work strictly on affordable housing issues, and we don't do foreclosure prevention or offer or refer housing. A core aspect of our organization's understanding is that where you live affects how you live. And so the ability to choose housing free from discrimination is important. As you can see, this graphic just shows some of the areas of our lives that our housing can affect. It can impact the types of jobs that are available near us, our wealth, our transportation options, our quality and access to education, physical mental health, exposure to pollutants and health hazards, healthcare options, and even our average lifespan. So because of the wide range of impacts of where housing is located, it's important that all people have equal access to housing and choice free from illegal discrimination. The Fair Housing Center West Michigan is one of several other fair housing centers in the state of Michigan. Each of us are independent from one another, but we have a working relationship with one another. On this map, you can see our service area is in the teal color. That's kind of the entire UP and then the western upper part of Michigan. If you call us needing assistance, but live in another Fair Housing Center service area, we'll kindly get you connected with the appropriate center to meet your needs. So I mentioned the word fair housing a few times, but I haven't defined it. So what is fair housing? Fair housing is the right to choose housing free from unlawful discrimination based on protected classes under federal, state, and local fair housing laws. The Federal Fair Housing Act and Michigan law protect from discrimination in any housing transaction. This includes things like rentals, sales, lending, insurance, land use, zoning decisions, and much more. As I mentioned earlier, fair housing protects people from discrimination based on protected classes. I like to think of protected classes as characteristics about a person. The classes protected by the federal fair housing law include race, color, religion, sex, disability status, familial status, and national origin. I just want to note a few things about federally protected classes. In case you're not aware, color refers to skin color. Disability status can include both physical and mental disabilities. Familial status is the presence of children under the age of 18 in the home. And national origin is the country of an individual's birth or where their ancestors originated. Additionally, we won't talk a ton about this, but the U.S. Department of Housing and Urban Development has a set of rules that they call equal access rules. These are a set of guidelines for HUD-funded properties and programs to promote equal access. These guidelines provide protections for marital status, sexual orientation, gender identity, and the composition of the family. These protections are not laws, but they are enforceable guidelines for HUD-funded properties and programs. At the state level, we have protections for marital status, age, an expanded definition of race, sexual orientation, gender identity, and gender expression, and source of income in rental housing only. A few things to note about state level protections are there are exceptions for age protections for certain types of senior housing. We have a lot of training material on that. We won't cover that a ton in this training. Additionally, the Crown Act, or Creating a Respectful and Open World for Natural Hair, was passed in 2023. This act expanded the definition of race to include hair texture and protective hairstyles. Sexual orientation and gender identity and gender expression protections were put into place last year in 2024, and source of income protections recently went into place in April. Finally, we also might have additional protections at the local level based on where you live. You can find more information about that using the resources linked on this page, which should also be linked in the handouts you should have received. Another important law we want to briefly highlight is the Violence Against Women Act, or VAWA. VAWA provides specific protections for victims of domestic violence, dating violence, and stalking, regardless of gender. Domestic violence cases in private housing have also been successfully filed under the gender protections of the Fair Housing Act. VAWA applies to federally funded public housing authorities and participants in Housing Choice Voucher, Section 8 voucher, and project-based programs, among others. While we won't go into depth about VAWA today, we do believe this law is especially relevant when it comes to fair housing rights for Native American communities. In the United States, there's a devastating amount of violence against Native American women. More than 4 in 5 Native American women have experienced violence, and more than 1 in 2 have experienced sexual violence. Additionally, while data is limited, the number of missing and murdered Native American women is deeply alarming. So we won't be able to go into depth about this issue today. We do encourage you to watch our YouTube video on the topic of VAWA and sexual harassment, which is linked on this slide. So that was a lot of information. That there's a lot of protections when it comes to fair housing laws. That's just our broad general information. So what exactly is illegal under fair housing? It's illegal for there to be differences because of a protected class in advertising, steering, eligibility criteria, application, policies, terms and conditions, discounts and specials, maintenance, access to amenities that are affiliated with housing, and harassment, which includes intimidation and sexual harassment. We want to emphasize that for something to violate fair housing laws, differences in treatment and housing has to occur because of a protected class. So fair housing laws require that each person is treated in an equal way by an institution, regardless of race, religion, age, sex, disability status, and more. When we think about what's covered by fair housing, we should focus on this term dwellings. Dwellings are covered by fair housing laws, and they include this whole list of potential housing dwellings. So apartments, houses and condos, housing construction sites. This includes empty lots intended to be used for housing, homeowners associations, mobile and manufactured home developments, and so much more. Now that we've covered what fair housing is, what's illegal and where it applies, we'll focus on what housing discrimination looks like today. So last year, the National Fair Housing Alliance, or NAFA, released their 2024 Housing Trends Report. In 2023, 34,150 fair housing complaints were received by private nonprofit fair housing organizations like our agency, HUD, Fair Housing Assistance Programs, agencies, and DOJ, Department of Justice. This is the highest number of complaints recorded since NAFA began producing its trends report in the mid-1990s. The highest number of complaints were on the basis of disability, followed by race. More locally, in 2024, our organization had a total of 168 allegations in 142 cases. Over 300 allegations of discrimination were reported to us in 2024, but for a variety of reasons, not all these allegations became cases. The top area of allegations are based on disability status, race and color, and national origin. Most of our allegations in 2024 occurred in rental housing, and a large number were reasonable accommodations. In case you all didn't know, reasonable accommodations are a change or exception to any rule, policy, procedure, or service needed for a person with a disability to have equal access to and full enjoyment of their home. An example would be if a housing provider has a no pet policy, but someone with a disability needs an assistance animal, a reasonable accommodation would be an exception or change in that no pet policy. So now that we've covered some grounding information on fair housing, we'll jump more specifically into our focus on Native American communities and fair housing. Just a note on the language, before we begin, we want to take time to talk about the language we're going to use throughout this presentation. As a civil rights organization, we are aware that there isn't universal agreement on appropriate race or ethnicity labels for diverse populations or in our communities. Throughout this presentation, we'll be talking about Native American fair housing rights and housing discrimination issues, particularly around the protected classes of race and national origin. We do know that race in particular can be a problematic descriptor for Native American identities, which is often characterized as political and legal identities in addition to racial ones. The reason why we focus on race and national origin, as imperfect as these labels might be, is that in many cases of housing discrimination mentioned throughout this presentation, they'll include allegations of discrimination against Native Americans because of their race or national origin. That's how the cases are filed. So when we're thinking about Native American populations in the United States, specifically with the data we're using in this presentation, we're using the census, the U.S. Census Bureau's definition of American Indian or Alaska Native populations. They define these populations as a person having origins in any of the original peoples of North and South America, which includes Central America, and who maintain tribal affiliation or community attachment. In 2020, the most recent decennial census, the Census Bureau reported that there were 9.7 million people who identified as American Indian or Alaska Native alone, or in combination with one or more races. In the United States government recognizes 574 American Indian tribes and Alaska Native villages in the United States. Federally recognized tribes are sovereign governments that exercise direct jurisdiction over their members and territory, and under some circumstances over other citizens as well. We want to note that federally recognized tribes are not merely organizations of citizens who happen to be of Native American descent. Federally recognized tribes have a government-to-government relationship with the United States, and tribal governments provide a wide array of governmental services to their members, including lawmaking, tribal police, court systems, health, education services, and many more. In Michigan, there are 12 federally recognized tribes that you can see listed here. We want to note that states generally do not have legal authority over tribal governments and tribal members that are inside a tribe's territory. A tribe's territory is defined as land that's designated as a tribe's reservation or trust lands. So based on what we talked about, how do fair housing laws apply to Native American tribes and populations? Because Native American tribes and populations are sovereign governments with jurisdiction over their own members and territory, how do these laws in the United States apply? So generally, fair housing laws do not apply to housing on tribally owned or governed land. There are some exceptions, but we don't have a ton of time to dive into all those exceptions today. Even though fair housing laws generally do not apply to tribally owned land, we do believe it's vital that Native American populations understand their fair housing rights under federal, state, and local laws, because many tribal members reside in housing off of tribal lands. While some Native Americans live on tribally owned and governed land, many live in cities and towns outside of tribal jurisdiction. The Indian Health Service estimates that approximately 87% of the American Indian and Alaska Native population live in urban areas, while 13% live off reservation or tribal lands. While communities across the United States are facing housing shortages, many Native American reservations and communities are also facing especially severe housing shortages. This often forces many Native Americans to find housing in nearby communities surrounding reservations. Here's just a statistic on some of the housing shortages and some of what it takes to just build land in tribally controlled areas. So why we think fair housing is important to this topic today is because many people who are Native American do not live on tribal land. And so fair housing laws apply to these populations. On top of hardships already faced in a severe housing shortage, Native Americans also face housing discrimination when seeking housing. The most recent study from HUD found that 1 in 4 Native Americans are discriminated against when attempting to rent homes. This study from HUD took place in metropolitan areas in New Mexico, Montana, and Minnesota, and used a sample of 397 paired tests to measure housing discrimination. The adverse treatment that was experienced was primarily the denial of information about the availability of housing units. Testing on Native American prospective homebuyers was only conducted in New Mexico, where Native Americans experienced consistent adverse treatment 16.6% of the time when compared to white testers. The adverse treatment was primarily steering. So now I'll turn it over to Liz to cover protections for race, color, and national origin.
Thank you, Lindsay. And again, we welcome questions, so feel free to use the Q&A to pop questions in there. You can submit them anonymously through that feature as well. And I also just wanted to share, if you're not familiar with the term steering under fair housing, that is essentially a behavior. It's often associated with sales, where a real estate agent might steer someone away from a particular neighborhood or steer them into a particular neighborhood based on a protected characteristic or an assumption about where people might feel more comfortable. It also happens in rental housing. For example, we've had cases where families with young children are placed or steered into one building, and then the other building on the property was kind of held back for anyone with older children or people without children. So that's an example of steering. And that's really a problem because it removes choice. It takes away the ability of the housing seeker to make a decision of what works best for them based on the housing that's available. So that's a behavior we definitely discourage. It still happens, even though it does sound like it's a little bit of an older term. So we do want to focus on the race, color, and national origin protections under the Fair Housing Act. These are important to differentiate and understand, and we also want to reiterate that people can file cases or make housing discrimination allegations on the basis of one or more protected bases. So we do sometimes have cases that are about race and national origin, or color and race. It could also be race and having a disability, or national origin and your familial status, how many children you have. So I just want to make sure that that's clear. And if there's ever any questions about what a fair housing violation might be occurring, or if you're not sure if something is a fair housing violation, we encourage you to reach out and talk it through with our team. It's our job to kind of listen and tease out any bases for fair housing actions that we could take. It can be very gray. And so it's, something that we want to err on the side of caution and encourage you to reach out to us or your local fair housing center. So back to our kind of our definitions or our understanding. Race refers to a person's racial background. So examples would be white, Black or African American, Asian, American Indian or Alaska Native, Native Hawaiian or Pacific Islander, and more. Color refers to the visible color of a person's skin, such as light or dark. National origin is the country of an individual's birth or where their ancestors originated. So this would include someone's birthplace, ethnicity, ancestry, culture, whether or not they have an accent, what language they speak, what appearance they might have that would be associated with a specific nationality, and more. So we wanted to highlight some particular areas of concern for our topic today. So any difference in treatment on the basis of a protected class is problematic under fair housing, and this would include discriminatory statements or questions. And I do want to highlight that discrimination that Native Americans experience is highly underreported, probably one of the least reported types of discrimination that occur. So that's why we're really grateful to highlight this topic, grateful for all of you logging on to listen and learn more about what this type of discrimination can look like so that we can more successfully challenge it. So there's really only a handful, several dozen cases, many of which are in the lending arena. So it can be really hard to find cases, but we really dug deep and found some shared experiences. And one was a really fantastic look from an National Public Radio or NPR article that interviewed Ken Heba, an Eastern Shoshone tribe member who was looking for housing. This is been an ongoing topic of concern across the country is our national housing shortage. And he detailed his experience as being profiled. He was asked a slew of racist questions focusing on stereotypes about Native Americans when he was searching and applying for housing. And the quote from Mr. Heba, "That's the first question. Do you party? Do you drink? Do you have a lot of people? They already assume I'm going to do something like that. And that's where I feel like I'm being discriminated against because of my race." So they're profiling him and then asking him questions on the basis of these stereotypes. Refusing to show a home or present a home as available or saying it's not available when it is available because of a protected class is a problem under fair housing laws. Specifically with this example here, this is changing the housing availability because of the applicant's name being associated with Native American culture. So this was another news article that interviewed Eric, or was written by Eric Tegethoff, who detailed the experience of Les Left Hand, a Native American man in Billings, Montana. He shared that he felt his last name was a barrier for he and his wife when they were looking for housing. Housing providers were unwilling to talk with him when he used his last name, so they started using his wife's maiden name, Martin, instead of putting Left Hand as the last name on the application. And they found that housing providers were more willing to work with them. So that's kind of profiling based off of the name and making assumptions about the name. That we also see differences in identity verification requirements and then also criminal background screening standards applied to Native American applicants. We do uphold that housing providers, landlords can ask applicants for identification for safety reasons or to verify their identity, but these policies really must be applied to everyone, not just selected applicants or kind of a decision made on the fly. Instituting a new policy based on a protected class would be problematic. So it should be a consistent policy that's utilized across the board, regardless of who is seeking the housing. For example, if a property manager takes a copy of a license or holds a license with identification information during a tour with a staff member, for example, that should be applied to everyone, regardless of who is there to tour the housing that's available. Additionally, housing providers can screen for criminal history. This is a new area where we're seeing a lot of cases, case law, and some communities enacting fair chance laws that limit or prohibit criminal background screening. But at the moment, generally, it's still largely something that is allowed. And again, if this policy exists, it should be applied across the board to every applicant and not just a limited number of applicants based on a protected class. We do want to share because we recognize that people hold multiple identities, that every person in the United States who is here, living here, is protected under the Federal Fair Housing Act, regardless of their citizenship or immigration status. They have the right to exercise their fair housing rights under law. It's not a violation if housing providers ask applicants to provide documentation of citizenship or immigration status during the screening process, but they must apply any such screening standard uniformly to all applicants. They could not only ask Native Americans with dark skin, for example, for documentation, but not other people. That would be a difference in treatment that would be problematic. A fairly recent case out of New York is an important one that has been really helpful in raising awareness and also resulted in some sample policies, which is always a good thing because we do have a lot of housing providers who are looking to follow fair housing law and be in good compliance. Not everyone does. Obviously, as you've seen, we've had some significant jumps in cases and particular types of cases. So this is a really important case that led to some good best practice information. Unfortunately, it is a result of discrimination that this couple did endure. In 2019, Ernesto and Corinna Zuniga were home seeking, looking to rent an apartment. They found a perfect one at Aspen Grove. This is managed by Residential Management, also called RM. They met income and credit requirements for the property. Their application, unfortunately, was denied because RM strictly enforced a policy requiring that all adult residents of their properties have a Social Security number or SSN. Ernesto had a Social Security number, but their application was denied because Karina, who was lawfully present in the country, was in the process of getting hers but did not yet have one, and that resulted in their application being denied. They reached out to their local fair housing center. Again, this is out of New York, And as centers do, they conducted an investigation of all RM properties. They confirmed the existence of the Social Security number policy and discovered two additional policies that were problematic under fair housing laws because they discriminated against families with children, and also they didn't have criminal background screening standards that were in compliance with the guidance available from HUD. They had an unduly or overly restrictive occupancy limit for their 2 and 3 bedroom apartments in some of their properties. So essentially, what that means is they established the number of people who could live there and then lowered the number. So we recommend that any housing property really look at utilizing local code to set the number of people who can safely live somewhere and follow that code and not round it down, which was the case here. They also enforced a blanket ban, which HUD has uh, really prohibited as discriminatory. So regardless of the nature of the conviction or how long ago since the conviction had occurred, they didn't care. They just had a blanket ban. They also had language that implied a really broad ban, which really essentially discouraged applicants from applying, and basically asked people to certify that they had no criminal history of any kind, which is not a current best practice. We will circle back to that in a little bit. The HUD complaint alleged that their Social Security number policy had a discriminatory impact because of national origin. The criminal history policy discriminated on the basis of race, and occupancy discriminated on the basis of protections for families with children. So the respondent denied the allegations, which is very common in settling cases like this, but they did agree to settle, and they agreed to pay $100,000 for damages and legal fees. They agreed to change their overly restrictive occupancy policy to conform with HUD guidance. They also adopted a new criminal history policy that limits the convictions that can be considered, and also requires kind of an individualized assessment. So they really had to bring a lot of their internal policies up to date, including how they verify identity. So instead of the requirement that all adult residents of their properties have a Social Security number, they now accept a wide range of documents for identity verification purposes. And here's kind of a snapshot of the sample policy that is part of the settlement agreement. A company could choose to adopt this and insert their name right there where we have the word company. They won't require applicants or tenants to provide that Social Security number or an ITIN number, which is an individual taxpayer identification number, as a condition of acceptance of an application or as a requirement for tenancy. So they significantly broadened the list of acceptable forms of documentation, including federally recognized tribal issued photo IDs. So there are many other signs of possible discrimination. Um, a housing provider refusing to just flat out show or sell a home to someone because of a protected class, a house having a for sale or for rent sign still up and you're told it's not available. Oftentimes when this type of situation comes to our attention, our clients are saying, I'm seeing people are still touring it. I'm seeing that people are coming and going and it looks like showings are still happening, but I'm being told it's not available. And so then the burden shifts to the housing provider to prove that that's not discrimination. You can be provided conflicting or differing information from another applicant or home seeker based on race, for example. We've had a number of cases where people were treated differently based on race as they were seeking information. They were quoted higher rental rates, for example. I talked about steering, being steered to certain neighborhoods, communities, or even buildings or floors within a building because of your known or presumed race or national origin would be a violation. You're told you won't be safe, the neighbors wouldn't want you there, or the neighborhood is not quote unquote right for you. So these are all signs of possible discrimination. Any changes in price, terms, conditions, availability that changes once there's a person-to-person interaction where the housing provider can see the applicant, that could be discrimination unless they have a non-discriminatory reason for making those changes, and they'd have to be able to prove that. That could be discrimination. Having a policy such as all tenants must speak English, being treated differently because you or someone in your family speaks with an accent, being charged a higher rent, a higher security deposit than neighbors of another race or national origin, or as we just looked at with the Zuniga case, having a limited list of acceptable forms of identification. We'll briefly talk about limited English proficiency or LEP protections here as well, because it's a correlation with national origin protections. So LEP refers to someone's ability to read, write, speak, or understand English. It is not a protected class under the Fair Housing Act, but housing providers are prohibited from using one's ability to speak English selectively based on a protected class. It can also be used as a pretext for discrimination because of a protected class. And there's multiple pieces of guidance from HUD and the Department of Justice addressing LEP. And it especially is important to note that housing and programs that have federal funds or federal financial assistance must comply with LEP guidance. We also recommend that the private housing market look to this guidance as well for best practices and what not to do. So the Fair Housing Act, requires those recipients of federal dollars to provide translation services for limited English proficiency persons. This often results in the American Indian, Alaska Native populations being overlooked because they do tend to focus on majority immigrant or refugee populations in the community. Native Americans are more likely to have limited English proficiency compared to their white counterparts. 1 in 10 non-elderly American Indian and Alaska Native people report speaking English less than very well. And it's been reported that in some census tracts in Alaska, 75% of Alaska tribal households do not speak English. So again, the lack of English proficiency can be a proxy for national origin discrimination. Practices that restrict access to housing on the basis of LEP can have a discriminatory effect based on national origin, race, or other protected characteristics, even when the housing provider has no intent to discriminate. The fair housing laws do not require for the intention behind the policy or the behavior to be discriminatory. If the result is discriminatory, it is likely a violation. Courts have recognized for quite some time that an individual's primary language skill generally does flow from one's national origin, and persons of different nationalities are often distinguished by speaking what we would consider a foreign language. Some signs and examples, we talked about having a requirement that all tenants speak English, or someone being turned away because they're not fluent in English. Bans on tenants speaking non-English languages on the property, or staff disparaging tenants for speaking non-English languages. We've had those situations pop up. A housing provider refusing to work with people who speak a certain language, but working with others who speak English languages other than English. So kind of treating one particular language speaking group negatively. A housing provider treating someone differently because they speak with an accent when they speak English, or being targeted for unfair or illegal housing related services because of their LEP status, kind of taking advantage of the population not being fluent in English. And that's certainly something we've seen, particularly in lending cases. Persons with limited English proficiency should be allowed a reasonable amount of time to take a copy of a document, to have it inspected by legal counsel, reviewed by a third party, or translated. They should be allowed to bring a third party to interpret, or a family member who speaks English to a high degree of competency as an alternative. And again, a reminder, federally assisted housing and programs have a greater obligation and must take reasonable steps to provide meaningful access to the information and services they provide to LEP applicants and beneficiaries. And we can provide a lot more information on that and direct links to some of the best practices and guidance if that's something you're interested in learning more about. In terms of harassment, we wanted to raise this issue so that you are aware that this is a protection offered by fair housing laws, which do prohibit coercion, intimidation, threats, or interference with any person in the exercise or enjoyment of their rights that are protected by fair housing laws. So this would be subjecting a person to harassment because of race or national origin, to the point where they either vacate the dwelling, they move out, they feel like they can't stay, or they give up, they abandon their efforts to rent the apartment, buy the home, etc. So it has to have that correlation between the protected class and causing someone to either vacate their current housing or give up on accessing the housing. Those are kind of the thresholds that must be met there. There's two types of prohibited harassment, which includes sexual harassment. And really, for sexual harassment, it's more of that quid pro quo standard of, I'll fast track your application, or I'll give you a discount if you go on a date with me or have a sexual relationship, wanted or unwanted. That really can be very problematic. Or the creation of a hostile environment where there's such constant harassment, unwanted touching or groping to the point that it creates a severe and pervasive amount of harassment that results in a hostile environment. Retaliation is also prohibited if somebody tries to report that they're experiencing harassment or that their fair housing rights are being violated. And if the response is to try to evict, collect fees, an escalation in harassment, anything that's an adverse action against the victim, that is prohibited by fair housing laws. Owners, property management employees, and agents can all be liable for harassment behaviors, as can tenants who harass other tenants. The National Fair Housing Alliance has done a quick study of complaints on the basis of harassment. This was released last year in their report as well, because they noticed a steady uptick and then it really skyrocketed in terms of complaints filed in 2023 on the basis of harassment in housing. It jumped 66% from 2022. Within that 1,500 plus complaints, the basis for harassment first was disability-based harassment, followed by race-based sexual harassment, harassment against families with children, and then harassment on the basis of color, meaning skin color. So examples of illegal harassment would be subjecting someone to pervasive racial epithets or slurs, defacing someone's home with racially derogatory or threatening words or images. We've had that happen a handful of times in my time here at the Fair Housing Center of West Michigan. Blocking access to dwelling or property amenities, such as not allowing families into swimming pools, not allowing people to use the gym or the laundry. Or a property management company learning that a tenant has been repeatedly harassing another tenant because of their race or national origin and taking no action to stop it. Any housing provider who becomes aware of harassment on the basis of a protected class must take action. That is very clear from guidance and case law. This is a couple out of California who experienced a difference in treatment and harassment under fair housing laws. They had rented a home for 4 years and had no prior issues in their experience. During their tenancy, the couple did inherit an altar and the rights to perform rites from a tribal elder. This Native American couple wanted to build a sweat lodge with a pit to heat stones because of their inheritance and ability to do the rites. They did consult with a fire marshal to ensure safety. So they were taking this very seriously and preparing very carefully. A sweat lodge was to be used for communal prayer and ceremonies. Their landlord wrote an addendum with standard provisions for fire code, but also included a statement that no guests were ever allowed in the sweat lodge. After it was built, the couple hosted a ceremony to pray for a specific individual. During the ceremony, the landlord stormed in and kicked everyone out. Those who had gathered there begged him to let them finish the ceremony. He stayed there standing over them as they did so, and then made them dismantle the lodge afterwards. The landlord told those who were there that it was not a safety issue. The investigation has revealed this landlord has also rented out a home to a white couple who also had a sweat lodge. Their addendum did not prohibit guests. So this case is being handled by a local fair housing center. And we'll try to find information as it moves forward. It can be very challenging to find out or take a long time to find out how cases resolve because sometimes they can take years. Another case, this is based out of a fellow fair housing center here in Michigan. Sarah Yoder, a Native American woman, filed a federal lawsuit with the help of a Michigan fair housing center against a landlord, Ryan McDonald, for sexual harassment. She had reached out to McDonald in August in 2018 regarding a property that was advertised for $700 a month in Lansing. She toured the property and tried to negotiate with him via text, asking to rent it for $650 a month. And McDonald began to respond with really inappropriate language. So I do want to remind you of our content warning here. He stated that he bet she would be more fun to negotiate with in person. 3 days later, he reached out again to ask if she was still interested, and she said that she was. And he responded that they might be able to make a deal if she performed a striptease for him. She responded, absolutely not. She's not going to do that, even for a house. This was her final message, but not the last one she received from him. So she cut off communication, but he continued to message her, saying he wasn't calling her a hooker or asking for sex, and that she wouldn't have to get naked just to do something cute, maybe, and let him watch. Later, she saw the same property listed as she continued her housing search. One of the impacts of housing discrimination is you lose out on the housing opportunity and you still have to find somewhere to live. She found the same property was listed by someone else named Jason, made an appointment. This time she brought a friend after her initial experience being so bad, and McDonald showed up. He exited the vehicle and berated her, saying that he was sweaty because he had been masturbating while watching her through their first visit. When she was leaving, he screamed at her and he called her a Native American racial slur. He continued to message her unwelcome and pervasive comments, which she maintained screenshots of as evidence. And in 2020, the case was settled for an undisclosed amount. However, that does not undo her experience. We initially talked very briefly about the use of criminal records, and so I wanted to provide a little more detail here. I'm keeping an eye on the clock, but just wanted to share that, again, while having a criminal record isn't specifically a federally protected class, there are some local communities like Detroit and Jackson, Ann Arbor come to mind, where there are local protections. And it's because many adults in the US, about a third of the US adult population, do have a criminal record that has kind of spurred a lot of studies, investigations, and new protections at the local level to help people overcome their lack of access to housing, which often impacts their ability to get a job. So we're trying to kind of break that cycle. In the United States, Native Americans are vastly overrepresented in the criminal legal system, as you can see here. They're incarcerated in state and federal prisons at a rate of 763 per 100,000 people. This is double the national rate and more than 4 times higher than the rate for white persons. They're also detained in local jails at a rate higher than the national level. Native American women are particularly overrepresented in the incarcerated population. This is 2010 data from Prison Policy Initiative. Native American women make up 2.5% of women in prisons and jails, despite only being 0.7% of the total US female population. So there's been kind of layers of HUD guidance related to the use of criminal records and background screening. The 2022 guidance kind of laid forth the standards for how criminal history screening can violate fair housing laws. It can be because of purposeful action taken to discriminate against people with criminal records. It can be a neutral existing policy that doesn't seem to discriminate, but once it is in practice utilized, it results in discrimination, or it's a failure to make an accommodation for a person with a disability, which Lindsay had explained earlier. Those are changes to policies such as a criminal background screening policy, as well as other services that a housing provider might offer. This guidance also cited research that stated that criminal history is not a good predictor of housing success, and that we're better understanding that utilizing criminal background screening is not really going to tell us whether or not somebody is going to be a good tenant. So there's more data and information available about the correlation that's often, I think, assumed that we're going to screen for criminal history and that's going to create a tenant pool that is very solid. Well, it's kind of being debunked by some of the research that's out there. It also states that private housing providers should consider not using criminal history if it's not going to help you create the a pool of tenants that you think it will. Examples of violations under this guidance would be routinely advising Native American applicants about a criminal record screening policy, but not doing so similarly with white applicants about the policy, not applying the policy consistently to all applicants across the board, rejecting comparably qualified applicants based on criminal record and other protected classes, favoring one over another, discouraging some applicants and encouraging others on the basis of race and other protections, even withholding applications. I recall someone reported to us, a Native American woman toured a property, met with the landlord, was very interested in it, and was having her African American boyfriend meet her there. The landlord was pretty open and communicative with her, but when the boyfriend arrived, he denied having any applications, even though he had been holding a folder of applications that the woman saw and refused to give it to them. Another example would be evicting a Native American tenant who's convicted of a crime, but not evicting a white tenant who's convicted of a similar crime. There was also some guidance released from HUD in 2024 about a lot of the technology, artificial intelligence, other technology being used for tenant screening. There's a lot of programs out there now that offer a lot of services about screening, and we're better understanding that those screening practices can result in discriminatory impact. So there are best practices provided throughout the screening set of this guidance from HUD, and it really builds on some of the earlier case law and the 2022 guidance. A lot of it makes a lot of sense. It's simply making sure that you have relevant screening criteria relevant to keeping people and property safe. Using accurate records, so not using some of the very bad data that's available out there, making sure that you're using data that has been, verified. You want to follow your policy. The housing providers also need to be very transparent with applicants. What is the policy? What are the standards you're being held to? And they should also allow applicants to provide additional information or accurate information or negative information. So having that opportunity to do an individualized assessment is really important. It also recommends that housing providers and the companies that create these screening platforms and tools make sure they are testing their models for fair housing compliance and design them with fair housing compliance in mind. There's also really interesting sections on credit and eviction history as well as criminal records that kind of helps us better understand the impact of credit history screening and eviction records can have on protected groups such as based on race, people with disabilities, women, families with children, domestic violence survivors, and many others. So again, a lot of that information is available on our website, but you're welcome to shoot us an email if you'd like to be directed towards something specifically that we haven't linked in here for you. So we really recommend policies be in writing and be available to everyone. There's that comparable treatment should be allowed based on the policy. Again, allow for that information exchange or the ability to kind of explain extenuating circumstances. That should be allowed universally across the board, but especially when there's going to be a denial. Evictions for criminal activity should only happen as a last resort and again, after an individualized assessment, finding out what happened. No one should ever be evicted because they have been victims of a crime. And invited guests of a tenant should not be banned from visiting based on the guest's criminal involvement. So that's from the 2022 HUD guidance, which encourages that policies do focus on the nature and severity of any criminal conduct and how long ago it occurred. Policies should really be tied to criminal conduct that has a demonstrable risk to resident safety and property safety. So differentiating between homicide and sexual assault and arson versus gambling, prostitution, tax, or cybercrime. And this is where we find the standard that all policies should avoid automatic denials and not affect blanket bans, meaning no felony bans, things like that. I'm going to hand it back over to Lindsay to talk a little bit more about lending discrimination, and I will be back on towards the end of our time together.
Thank you so much, Liz. We're going to jump into lending discrimination. So lending discrimination can look like denials, redlining, and unfavorable terms. So for discrimination through denials, an applicant's loan might be denied because of they're a member of a protected class. For discrimination through redlining, an applicant's loan might be denied because of the location of the house or the dwelling. And then for unfavorable terms, less favorable terms of a loan might be given to an applicant because they're a member of a protected class. So those are kind of the different types of lending discrimination that we see. Several studies have found that Native Americans, along with other people of color, pay higher rates than white people for home mortgage loans, even after controlling for borrowers' income, debt, and credit history. Foreclosure rates and usage of subprime lenders are also higher among Native Americans and other people of color. A 2019 study from Chicago found that nearly 1/5 of all home loan applications from Native Americans are denied in the city of Chicago. Native Americans are more than twice as likely to be denied a home loan compared to white people, and these differences also persist even after accounting for income. Additionally, to add an added layer of challenge, there can be confusion among private lenders about tribal sovereignty and jurisdiction and lending on tribal land, which we'll see in the following slides. So in 2023, the National Community Reinvestment Coalition, or NCRC, published a report focused on the pervasive practices of redlining on tribal lands. Their report looked at census tracts overlapping tribal lands in Arizona and New Mexico and used data from the Home Mortgage Disclosure Act, the Federal Financial Institutions Examination Council, and Native American National Data Alliance, and others. NCRC had several findings that apply to our discussion on lending discrimination today. One is that even with the federal program guaranteeing 100% of losses on loans, private lenders rarely provide conventional mortgages on tribal lands. None of the three largest mortgage lenders in the US participate in HUD's Section 184 program, which provides a guarantee on loan mortgages made in tribal areas. So that means that there's pretty limited financial risk for mortgage lenders. Out of the 2.6 million mortgage loan applications analyzed in the study, only a staggering 47,790 were loans with Native American applicants. This is 1.9% of the population of the applications that they looked at. And keep in mind, Arizona has approximately 6.2% of their population self-identifies as Native American, and in New Mexico, that's 10%. Another finding in this report is focused on manufactured homes. So because Native Americans have a hard time getting a conventional mortgage on tribal land, they often rely on manufactured housing. On tribal lands in Arizona and New Mexico, 49% of home purchase loans were used to buy manufactured homes. In census tracts without tribal lands, this fell to 4%, so 49 to 4. Loans on manufactured homes tend to carry higher interest rates than site-built homes because there's very little competition in the manufactured home market. So these are long-lasting financial implications for people who are Native American, who often have a hard time getting conventional mortgages on tribal lands. And then the last finding that we'll mention from the report is focused on financial need. So the report details that tribal areas in Arizona and New Mexico have far higher financial needs than other rural areas. NCRC developed what they call a financial needs index, which is a comprehensive measure of the level of access to services currently seen in a given area or community. NCRC took into account population density, minority percent of population, internet and smartphone access, vehicle ownership, and the distance to the nearest existing brick and mortar bank or credit union when they were producing this map. NCRC's index indicates that people living on tribal lands are not being served nearly as well as other residents of Arizona and New Mexico with access to financial services that meet their needs. So on this map to the side, it's a bit small, but the hotter the color of a given area, the more highly it should be prioritized in efforts to increase access to financial services, including mortgage loans. So those were some of the information that's more recent about lending discrimination and essentially redlining on tribal land, specifically in Arizona and New Mexico. Now moving into some cases on lending discrimination, we have a case from 2009. So in 2007, the National Community Reinvestment Coalition, or NCRC, sued Novastar Financial, Inc., a national subprime lender. They alleged that Novastar maintained discriminatory policies of prohibiting lending to properties involving row houses, properties on Indian reservations, and properties involved with adult foster care facilities. NCRC argued that the policies disproportionately had an adverse effect on African Americans, Native Americans, and people with disabilities. The case alleged that the no Indian reservation policy is facially discriminatory and explicitly treats loan applications differently based on race, color, racial composition, and national origin. Additionally, the case alleged that Novastar's policies had a significantly disproportionate and adverse impact on Native Americans and Native American homeowners by limiting their access to capital and availability of housing to Native Americans. In 2009, the case was resolved in an undisclosed settlement agreement where Novastar and their affiliates agreed to discontinue the discriminatory policies, implement training programs to ensure their practices are compliant with fair housing, and to compensate NCRC for the diversion of its resources and frustration of its mission caused by its discriminatory practices. More than $1 million was paid to resolve these claims. And then there's another case out of North Dakota. In May of 2013, a Native American couple in Belcourt, North Dakota, which is located within Turtle Mountain Reservation, applied to refinance their mortgage with U.S. Bank. Although the couple's property was located on a Native American reservation, it was held in fee simple, which means that the couple had the title to the property without restriction, in the same way that land is generally held throughout the United States. In June of 2013, the couple received correspondence with U.S. Bank stating that their loan application was denied because value or type of collateral not sufficient. The couple alleged that U.S. Bank told them that their loan application was denied and an appraiser could not appraise their home because it was located within the boundaries of a Native American reservation. The couple filed a complaint with HUD alleging discrimination because of their race. In 2014, HUD reached a settlement with U.S. Bank to resolve the allegations of lending discrimination against the couple. The terms included that U.S. Bank would agree to pay the couple's U.S. Bank credit card balance of $11,489.56. U.S. Bank also agreed to approve the couple's application for a home mortgage refinance loan at the same interest rate and under other terms and conditions for which they originally applied. And they also agreed to amend their policies regarding home mortgage loans on land located within the boundaries of Native American reservations to be consistent with the Fair Housing Act and provide fair housing training for their employees. So now we'll move into occupancy standards. As we discussed earlier in this presentation, familial status is a protected class under the Fair Housing Act. The act was amended in 1988 to add familial status protections and protections for people with disabilities. It is unlawful under law for people to experience discrimination because of their familial status. Familial status is defined as one or more individuals who have not attained the age of 18 living in the home with a parent of another person having legal custody or such individual or designee of such parent or other person having custody with written permission of the parent. These protections also apply to any person who is pregnant or in the process of securing legal custody of an individual under the age of 18. In less legal language, a family under the law includes a single individual, people who are pregnant, people in the process of adopting or securing legal custody, foster parents, and grandparents raising grandchildren. We have a study cited here that emphasizes that Native American family networks and households are more structurally open when compared to ideas of family in Western society. Native American family units can often encompass many generations, which makes it hard to find housing and can lead to challenges with housing providers when it comes to occupancy standards. So let's talk a little bit more about occupancy standards in housing. A housing provider's occupancy policy can reasonably limit occupancy based on local health and safety codes. Reasonable occupancy requirements are typically based on the number and size of bedrooms and sleeping areas, the overall size and configuration of the unit, physical limitations in the structure of housing, the age of children with caution, and other similar factors. Something to note is that if a family has a newborn child that expands the family above the legal occupancy standard, it is reasonable for the housing provider to allow the family to remain in the housing at least through the end of their lease or even up until the child's second birthday. A fair housing issue that we see with occupancy standards is overly restrictive standards. The Fair Housing Act protects against occupancy rules and restrictions that unreasonably keep families with children from finding a place to live. Occupancy standards should not be more restrictive than local health and safety standards or other governmental restrictions. Many landlords use the rule 2 people per bedroom or 2 heartbeats per room, but these rules may not always follow fair housing laws. Housing providers only need to know the total number of people who occupy the unit. If you have questions or concerns about occupancy standards where you live, please contact us. Our phone number and our email are listed right here. The following are statements about occupancy that are not true, including parents have to have their own bedroom, boys and girls cannot share a bedroom by law, 2 heartbeats per room is Michigan law. If you have a baby, you have to move to a bigger unit, and no more than 3 persons shall permanently occupy or reside in any 2 bedroom unit, or no more than 4 persons in any unit which has been expanded to include a 3rd bedroom without the express prior written approval of the association. These policies or statements can be overly restrictive when it comes to occupancy. So now jumping into a case example from 2018 focused on Native American families and occupancy. In September of 2016, the Brown Moreno family sought housing that would accommodate their extended family arrangement. Deborah Brown, her partner Nehemiah Joe, and her 2 sons planned to rent a home with Camille Moreno and Deborah Brown's and Anthony Moreno and their 5 minor children. Camille Moreno is Deborah Brown's adult daughter. So this is a multi-generational family who would like to live together. Camille Moreno, Nehemiah Joe, Deborah Brown, and her sons are Native American. Anthony Moreno is Mexican American, and the Moreno children are of Native American and Mexican American descent. The property the Brown Moreno family was interested in renting was a 6-bedroom, 5-bathroom home with over 7,000 square feet of living space. It included 2 kitchens and many other amenities situated over 8 acres in Beltrami County, Minnesota. To add more names to this case, Hans and Corey Serleth owned the property and they hired someone named Barbara Raymond, a realtor and the owner of Lakes and More Realty, which is also known as Bemidi Property Management, to sell the subject property or to rent it out until a sale could occur. At the time the Brown Moreno family submitted their rental application for the property, it was currently under lease by the Sanders family, who were looking for a subleasee. The Sanders family had recently vacated the property and they knew Deborah Brown from work. Initially, the Brown Moreno family was told by the respondents, allegedly, that their rent would be $1,000 a month higher than the rent of the current tenants, which were the Sanders family. Later, the Brown Moreno family's application was denied by the respondents, despite the family's willingness to accept the terms and that they met all the financial qualifications. After the denial, the Brown Moreno family split up and they lived in separate residences. And because their application was denied, the Sanders family wasn't able to secure a subleasee and was forced to pay $15,500 to buy out the remainder of their lease. So some implications from this experience with the housing provider for each of them, each of the families. On August 3rd, 2018, HUD charged Hans and Corey Serleth and their real estate agent, Barbara Raymond, with race, national origin, and familial status discrimination. HUD alleged that the respondents refused to sublet the house to the Brown Moreno family, which consisted of 5 adults and 6 children, because they were Native American and Mexican American and had minor children. The respondents believed that the septic system could only handle 10 people, not 11, and they denied the allegations that in the charge that they told the Brown Moreno family that their rent would increase by 1,000. Ultimately, the respondents agreed to resolve the case with HUD, the Brown Moreno family, the Sanders, and the parties recognized in the consent order. And in the consent order, the respondents, the terms of the consent order, they had to acknowledge that the Fair Housing Act exists and it makes it illegal to discriminate based on race, national origin, familial status. They had to promise to comply with the Fair Housing Act. They paid $60,000 to the Brown Moreno family for damages, $14,000 to the Sanders family for damages arising out of the allegations in the HUD charge. They agreed to publish a fair housing advertisement, include the Equal Housing Opportunity logo in their advertisements, rental applications, and leases, and then receive further fair housing education and multicultural sensitivity education. So that is the case for occupancy standards. So now I'll quickly turn it over to Liz to close out our session.
Thank you, Lindsay. And thanks for submitting some great questions. We're doing our best to kind of multitask here. Please feel free to keep the questions going. I just want to briefly talk about our investigations program, which includes an opportunity for volunteer testing. This is an investigative tool that we use to gather evidence, and we do recruit volunteers who simulate ordinary housing transactions for the purpose of helping us weigh whether or not housing discrimination is occurring. So the testers can pose as home seekers, and they help us obtain credible and objective information about what is happening. We use our volunteer testers to investigate all types of housing and housing-related services. And the evidence that we gain through our testing program often forms the basis for a successful resolution of a complaint, because it can help us verify what is happening and often establish a pattern or practice of violations of fair housing law. So it's a really important tool that we utilize to help assess the situation, look at what's happening in terms of information provided, services provided, what sort of treatment people receive, and what sort of housing access they have, which really should be upheld without any impact of a protected class. Our investigations can find those differences in treatment, though, through our paired testing program. So if we expect that race-based discrimination is occurring, for example, for our topic today, we would send out a Native American tester and a white tester. They'd be comparably qualified. The Native American tester might be a little bit better qualified. They'd be looking for the same type and size of housing, and they would ask for the same and expect the same treatment. But what we find is that often there are changes in the quality of service, the information that's requested of our volunteer testers, and the information that they receive from housing agents, and they are often treated differently. It also can gather evidence of things that are said that are discriminatory and policies and practices. So if you are not a housing professional and you'd be interested in becoming a tester, feel free to reach out to our office. We are always looking to recruit new volunteer testers. It's a very flexible volunteer opportunity. We will train you. You do not have to commit to it, but we do have to represent the great diversity of all of our protected classes now here in Michigan. So we're always looking for folks who are willing to consider doing it. So let us know if you're interested. And then, of course, we want to very quickly talk about how housing discrimination can be reported. Anyone can report housing discrimination, even housing professionals. The data that we've shared in our presentation today represents really only a small portion of the millions of incidents of illegal housing discrimination that happens each year. At one point, it was estimated that 4 million instances of housing discrimination occur annually in the United States. And we're getting cases in the 330,000 plus range. So we are vastly missing a lot of cases. It often does go undetected as well. It can be very polite in terms of the service and treatment that someone receives, so people may not legitimately realize that they're being discriminated against. It can also be very difficult to verify or document the discrimination. That's where our testing program can be so critical to help people. It's often common for people who do experience discrimination to feel that nothing can or will be done about their civil rights being violated. There's fear of retaliation from the housing provider, their existing landlord, or neighbors. Others may discourage them from reporting as well. So we certainly want to acknowledge that. And that's why we encourage anyone who suspects discrimination to reach out and let us know about it. So our tips are remember, record, and report. So remember what happened when, record as much information, gather as much information, maintain screenshots, keep emails, keep printed copies of anything, make a timeline, write it all down, and report it to your local Fair Housing Center. You can report it to HUD or the Michigan Department of Civil Rights. But Fair Housing Center staff will walk along with you to assist you and or your clients with all of the steps that can be taken. So our services are free to represent clients who are alleging discrimination. We can take complaints by phone, email, letter. There's a page on our website. You can report it anonymously. You can contact our education and outreach team. We can remove identifying information. And if we have our client's permission, we can, try to advocate directly. It doesn't have to become a case or an administrative complaint. We will do whatever it takes to resolve the situation. We have a fantastic intake and office coordinator, so that's usually the starting point for an allegation to be made. The sooner you can contact us and the more information you have to give us, the better. Our clients can choose to litigate with cooperating attorneys or work with the Department of Justice or DOJ. They can file administratively with HUD or the Michigan Department of Civil Rights or the local government or municipality that has the Fair Housing Ordinance on the book. If it's their law, they are in charge of enforcing it. And sometimes we can involve professional mediation if both parties are willing. We always try to get the property if it's still available and if they still want it. We would love to see training so that it doesn't happen again. We want to see policies rewritten, and sometimes victims of discrimination do receive compensation based on their unique experiences and which laws were violated. So what can you do? Report it, talk about it, invite us to speak, visit our website, join our email lists to stay in touch. Thank you so much for logging on. Think about becoming a member through a donation. You don't even have to donate money. You can become an ambassador, you can become a tester. We really appreciate all of the support. We have one more training coming up this month on housing development and fair housing called Creating and Sustaining Inclusive Communities. That's Monday, July 21st. You can register online on our website. We ask that you complete the evaluation. We'll send that out also by email, but it should be open in your internet browser. Please complete it by the end of the day tomorrow. If you would like to request a certificate, you can do so by completing that evaluation. We are happy to stay on for a couple moments and make sure we answered any questions. I do want to acknowledge there were a couple of really good questions in the Q&A, and really thank you for reaching out to ask for more information. If you want direct resources like that sample policy about forms of identification, we can send you that case, we can send you that sample policy. Anytime there's a change in any sort of rental criteria, it should be scrutinized. We had a great question about credit scores, so I encourage you to check out that section on page 16 of the 2024 HUD guidance that kind of analyzes the discriminatory impact that credit score screening can have. People are allowed to use credit scores for screening, but it depends on if it's being actually utilized equally or not. So we would always need more information to fully assess something like that, but I really appreciate that point because it can have a huge impact on folks. And as we discussed, it can be very challenging to find cases and be able to share violations for this population because it's so underreported. We do just see, I think, a real lack of familiarity of working with Native American communities from housing professionals, and I think that's a real barrier. So we do appreciate everybody logging on to learn a little bit more about that and encourage people to take action and reach out. Just because you don't know what to do doesn't mean that something can't be done to provide housing transactions and housing access for this population. So I know we're a little bit over time, so I want to thank you. If you don't have any questions, feel free to log off, but we'll stay on for a few more moments here.